And very important, the deadline to submit the proof is 21 days from the date the application is filed. If a claimant does not provide the proof of self-employment or employment before the natural disaster rendered that person unemployed, within this deadline, if they receive benefits during the time while DO is processing the claim, that claimant is going to be found ineligible for benefits that they're going to be charged with an overpayment. In regard to the amount of benefits, the calculation is very similar to employment assistance, but the base period is fixed. What DO uses or is supposed to use in order to calculate how much someone is eligible to receive in DOA benefits is the most recent tax year that ended prior to the individual's unemployment that was the direct result of the disaster. And so it's a fixed period of time. And a claimant cannot receive more than $275 per week, which is the maximum under state law. And unlike employment assistance, the minimum is not $38. The minimum is 50% of the average weekly payment of regular compensation in the state. Under state law, is the minimum for employment assistance, as I said before, is $38. For this, if the weekly benefit amount calculation renders or yields a number below 125, which is that number for Florida right now, if it's less than 125, the claimant will receive no less than $125 per week in DOA benefits. And the disaster period is the 26th week, beginning with the first week following the date the major disaster began and ending with the 26th week subsequent to the date the major disaster was declared. So there could be a mismatch depending on the delay or how long it takes for the president to declare the disaster and from the disaster occurring. So someone could receive more than 26 weeks of benefits, depending if they're on this fact, if there is a delay.
Daniel, we have a question about the backdating claims. The question is, ordinarily in non-pandemic times, is there a time period within which the claimant must apply for reemployment assistance?
No.
Or they won't get benefits dating back to the separation? She says she's thinking about a worker who gets laid off but waits before filing because of chaos or the disaster, or their expectation that the business will call them right back.
Yeah, that's a great question, and it's a common occurrence, especially nowadays because of the pandemic. And the regular time, no, there is no deadline. So someone can wait months to file a employment assistance claim. The only problem or downside, or it could be also playing the advantage of the claimant to wait, is that the base period is going to shift. And if, for example, the claimant becomes unemployed and waits too long, and the new base period might not meet all the criteria or to render that claimant monetary eligible. That's the only problem. Sometimes, in many cases, actually, there might be a benefit of waiting because the wages on the last quarter don't count. And if someone waits and a brief period of time, they might be on a new quarter. And if they're in a new quarter, those wages that they didn't count will count, and someone can get more benefits, or that person can become monetary eligible when they were initially ineligible. So there is no deadline actually under any circumstance, and there could be a delay between separating from the job and filing the claim.
Thank you.
One thing that is important to answer that question too is that the claimant is eligible from the time they file the claim. So if there is a delay, that claimant is going to be eligible from the date that they file the claim, right? So waiting also might be a disadvantage depending on how long they wait until or how long they have to wait until they find a new job. But other than that, there are no deadlines. In regard to the appeals process of a DOE claim, the claimant has 60 days to appeal a determination or redetermination, and that first decision on appeal must be issued within 30 days. And what DEO, which also administers the first stages of this program, will do is schedule, once someone appeals, schedule a telephonic hearing before appeals referee. Once the appeals referee issues a decision, the claimant has 15 days to appeal the decision, and they have to appeal it to the Employment and Training Administration. And that's obviously if they disagree with the decision. And in the case of an individual, because the state can also appeal that determination if they disagree from the decision from the appeals referee. But in the case of a claimant, if they want to appeal, they can file appeal with the state directly, with the agency, with DEO, or what they can do is file the appeal with the regional administrator directly. And that's the regional administrator that is designated for the area where the claimant resides. In the case of the agency, they have to appeal directly, or the state, they have to appeal directly to the Employment and Training Administration. Once the appeal is filed, the regional administrator has 45 days to obtain the records relevant to the case and issue a decision. And the decision by the regional administrator must be issued within 90 days after the date on which the claimant filed the first appeal or was received by the state. And that decision becomes final unless the assistant secretary decides further review is needed. That they don't, if that's the case, the assistant secretary's decision will be the final decision and it cannot be appealed. That will be the present, not only will be the decision on the case, but will become precedent for the DCA program. Let's talk now about the Pandemic and Employment Assistance Program. This is one of the CARES Act programs, and this is probably the most popular one. What this program did or does is extend coverage of unemployment compensation benefits to individuals who are normally not eligible for employment assistance benefits. This is, just to give you an idea, a lot of law and rules in this program mimic or parallel the DOA program. In fact, where there is no law or where there is no law on point on an issue specific to a claim, the CARES Act and also the directives from the Department of Labor advise states to rely on DOA law to resolve those conflicts or those issues in the claim. And so the claimants have to be ineligible for employment assistance benefits or have to have exhausted all their benefits. They need to be able and able to work as defined in state law, except that the person or the claimant is unemployed, partially unemployed, or unable or unavailable to work because of the COVID-19. And that includes that, like DOA, self-employed individuals, independent contractors, people who didn't earn enough or work enough to qualify for employment assistance, or people who have exhausted all their employment assistance benefits or PUC benefits, which I'm going to talk in 2 minutes. And the benefit period for this program is January 27, 2020 through December 31st, 2020. So that means if someone lost his or her job because of COVID-19 in February, right? And they filed a claim today for whatever reason, they are technically entitled to receive benefits going back to the first time they became unemployed, provided that that date happened after January 27th. In practice, the state, for whatever reason, they just pick random dates. Claimants can still backdate these claims, but I haven't seen a claim that has gone back to February. Most of them go back to March 2020. This program offers 39 weeks of benefits, and a claimant doesn't need to show that the claimant is monetary eligible to qualify for this program, unlike employment assistance and like DOA. A claimant is not eligible for POA if the claimant can work or is receiving paid leave unless the PTO is for less than the customer work week, and is also less than the weekly benefit amount that the claimant is entitled to receive under the POA program, or the claimant teleworks and work less, and this program doesn't have waiting week. So the idea is that if someone is partially unemployed, even if they receive some sort of benefit from the employer, that person is going to be, provided they qualify for, they are covered under the program, they will qualify for POA. And the claimants need to show that they're able for work, and one of the COVID-19 reasons apply. And this is a long list. I'm not going to go through this because it's going to take me like 30 minutes. And so essentially, the person has to have lost the job or the ability to work because of COVID-19. And the most common example, which is I guess, more unusual given the circumstances nowadays of the pandemic is of people who were supposed to start a job and they couldn't because of the COVID-19 health emergency, public health emergency. And that's the case of people who were supposed to start working for the census, for example, and they couldn't start working because the census stopped operations because of the COVID-19 emergency. So those people are going to be eligible for this benefit. Base period is the year 2019, and like DOA, self-employment and wages are considered like treated the same. And unlike DOA, like DOA is a fixed base period. However, unlike DOA, it's the years 2019 is not the most recent tax year. And so if the claimant doesn't have any work history, they will receive weekly benefit amount of $125, which is the minimum like DOA, and the maximum is $275 per week. So briefly about the Pandemic Emergency Unemployment Compensation Program. This is just an extension of 13 weeks of regular RA benefits after someone has exhausted their RA benefits, and provided that the claimant or individual has been unemployed or claiming these weeks before, these weeks occur before December 31st, 2020. And the claimants become eligible for this benefit once they file a PUC claim, and they have to show they're able and enrolled for work and actively seeking work. Unlike PUA, they don't need to show that the reason why they are still unemployed is related to COVID-19. And if someone has COVID-19 or COVID-19 is one of the reasons why the claimant is not able and enrolled for work, the program is flexible to account for that and allow the claimant to receive the benefit. Like state benefits, the maximum weekly benefit amount is $275, the minimum is $38. The PUA, if you remember, was $125 like DOA. And in the extension, the PUC, the minimum weekly benefit amount is $38. The Federal Pandemic and Employment Compensation Program, this one has already expired, but I'm going to talk about this briefly because some of your clients might still be eligible for these benefits if they were claiming weeks, they were placed on hold, and those weeks occurred during the time this benefit was available to them. So once the issue with their claim is resolved, they are going to get paid the FPUC. So that's why it's important for you to know about this. And what this program did was provide us $600 supplement per week during the benefit period. And the $600 applied to anyone who was eligible for any of the employment assistance programs available at the state. So if someone was eligible for employment assistance, PUC or PUA, they get that benefit plus the $600. And claimants are automatically eligible for this. And this program became effective on March 29th in Florida, and it ended on March 25th, actually 26th. Oh, I'm sorry, in July 26, 2020, and it hasn't been extended. The appeal process for all these claims is the same as for employment assistance. It's 20 days from the day DO issues the decision. If DO will schedule, if the claimant appeals, DO will schedule a hearing before an appeals referee. The appeals referee issues a decision. Then the claimant has 20 days to appeal to the Employment Assistance Appeals Commission. Once there is a decision from an order from the RAC, the claimant, if the claimant disagrees, can appeal to District Court of Appeals. And here I list some of the resources that you can use to appeal cases. And finally, the Lost Wages Assistance Program, or LWA program. This one was created by the Trump administration to supplement unemployment compensation benefits after the FPUC expired on July 25th, 2020. So the $600 expired, there was no extension. Trump created this program with a memo, and what it did was pay $300 per week for 4 weeks and covered weeks of unemployment from week ending on August 1st through the week ending on August 22nd, 2020. Some of your clients who have issues with their claims, if they have not received payment for weeks that they claimed during that period of time, once the issues get resolved, they will get also the LWA program. That's why I'm talking about this now. And that's all for me. Any questions?
No more questions. And thank you, Daniel. That was a lot of information for everybody today. And as I said, you'll get a copy of Daniel's PowerPoint when we send you that, a link to the recording. So thank you, Daniel. Now I'm going to give Cindy a moment to share her screen and get started on the next part of our presentation.
Okay, thank you. Hopefully everyone can see my screen. I'm Cindy Huddleston from the Florida Policy Institute, and I'm going to talk just a few minutes about disaster SNAP and say a couple of words about pandemic EBT benefits also. So, so far this year, fingers crossed, DCF has not had to roll out a full-fledged DSNAP program. But just as a refresher course for next year, I wanted to say a few words about SNAP in a disaster. In a disaster, DCF most frequently does three things. It implements a disaster supplemental nutrition assistance program, which is DSNAP for short, and it rolls out replacement SNAP and supplemental SNAP. Now, DSNAP is an entirely different program from the regular SNAP program. DSNAP provides temporary food assistance for households affected by disasters who are not getting regular SNAP. DSNAP provides 1 month of benefits to eligible disaster survivors. And to be eligible for DSNAP, a household must live in the identified disaster area, have been affected by the disaster, and meet certain DSNAP eligibility criteria. Sometimes, although it rarely happens, if a state requests it, DSNAP can be extended to persons working in a disaster designated area. DSNAP responds to situations where a lot of families have disaster-related expenses that aren't considered by the regular SNAP program, and where the need is so great that the state really needs a streamlined process to get help out quickly to affected families. An affected area must have a presidential disaster declaration with individual assistance in order to trigger eligibility for a DSNAP program. But of course, as I said, DSNAP only happens if a state requests it and if FNS approves it. Each disaster is different, and each DSNAP program can be different too, based on the disaster and based on what's going on in the community. But there are a few elements that have been fairly consistent over time here in Florida, and I just want to highlight some of those. Student, citizenship status, social security number, work registration restrictions, they are not applicable to the DSNAP program. So that's good news for a lot of people who can't qualify for regular SNAP because of their status as a student, or because of their particular immigration status, or because they don't have a social security number, those kind of things. Liquid resources and income are added together to find disaster gross income, and disaster expenses are then deducted to determine financial eligibility for disaster SNAP. So it's a little bit cleaner and more streamlined process for doing a DSNAP budget than for doing a regular SNAP budget. You can usually buy hot prepared foods, which, as you know, you can't do in the regular SNAP program. And benefits are automatically going to equal the maximum for a family of the household size. There's much less red tape. In the past, you could register online, and since Hurricane Irma, you've been able to apply by phone. We're really hopeful that future DSNAP programs will continue the relaxed application process and allow for phone or perhaps internet applications, but that still remains to be seen, because this is a concept that FNS has really not embraced as enthusiastically as we might would hope. So why is there no DSNAP program for COVID? Because there certainly could be. There was a disaster declaration that was issued for Florida, and disaster SNAP was requested for Florida for COVID, but it wasn't approved by the president because the belief was that the CARES Act, some of which Daniel talked about, took care of food insecurity issues from the pandemic. But of course, that's really not true. There are many families who are not eligible for regular SNAP and who did not get relief from the CARES Act, who may have been able to qualify for DSNAP, and disaster SNAP would have filled that gap nicely, but it was denied, as it was, I believe, in every other state that requested it. Replacement SNAP. Replacement SNAP, unlike DSNAP, is for current recipients. It allows DCF to automatically replace all or a portion of a household's monthly SNAP allotment without the requirement that a household request the replacement, or travel to a local office to sign or turn in an affidavit of loss. This helps the household, and of course, let's don't forget, it helps DCF, who doesn't have to process cases manually for everyone who needs benefit replacement. As an example of how mass replacement worked under Hurricane Sally this year, in Escambia and Santa Rosa counties, 50% of a household's food assistance for benefits received between September 1st and September 15th were automatically replaced. And families whose benefits were issued between August 16th and August 28th got a 25% automatic replacement, all without any need to submit a request or to provide proof of the loss to DCF. Usually, benefits are good for 90 days, and you can buy hot prepared foods, which of course you cannot do with the regular SNAP program. Although in the regular SNAP program, benefits last normally for a year, or good for a year. Supplemental benefits are also for current recipients. They are designed to provide parity between new DSNAP households and ongoing clients who aren't eligible for DSNAP benefits. And they do this by automatically increasing benefits of current recipients up to the maximum amount for the household size, just like DSNAP households did. I want to say a few words about PEBT, Pandemic and Electronic Benefit Transfer, which was a brand new program created by Congress to respond to COVID. Originally, PEBT provided food assistance to Floridians with children who were eligible for free or reduced priced school meals, but whose school was closed in the spring of 2020 due to COVID-19. Fortunately, under a federal continuing resolution that became law on October 1st, states, if they want to, can ask USDA for permission to provide PEBT in 2020-2021 to not only children who have a reduced number of days or hours that they are physically present in a brick and mortar school, but also to children in childcare. This includes students who opt for distance learning in Florida, and there are many of those, at least I know in my county, that there are thousands of children who have opted for distance learning. Now, I can't give you a lot of details about how this is going to play out or what the requirements are, because those have not been released yet. And so we're still waiting eagerly to hear details about how this is going to work and when we hope it will be rolled out in Florida. I'm not going to go through the slides about how PEBT worked in the spring, but you'll have this PowerPoint. But suffice it to say also that millions of children in Florida received benefits of up to $313 a month. And we're hopeful that even more will be eligible and receive PEBT in Florida this school year, and we will keep you updated. One of the important takeaways about PEBT to remember, though, is that immigration status should not be considered in determining PEBT eligibility, and it should not be part of a public charge determination, although there has been, full disclosure, been no clear affirmation of this from the federal government. So here is my contact information. If you have any questions about this webinar, or if you want to brainstorm cases, I would love to hear from you. I miss my communication with all the old legal services folks and people in the disaster community. So please keep this contact information nearby, and I look forward to talking to you.
Thank you. Thank you, Cindy. And as Cindy said, you'll get a copy of her PowerPoint as well, and her contact information when I send out the recording. And so now Cindy's going to stop sharing her screen, and Ann is going to share her screen and talk to us about Medicaid and health issues.
Okay. And let me make sure, Kathy, is this the full screen?
Yes, it's looking fantastic.
Great. Okay. Hi, everyone. Hi to old friends. And I know we're sort of at the end of the hour, so I'm going to go quickly through my presentation, but please feel free to contact me after if you have questions, and my contact information will be on one of the slides. Let's see here. All right. For some reason, I'm having trouble with, there we go. I'm going to start here. Just a little bit of what I'm going to try to cover today. First, just a very high-level overview of what is Medicaid. Some of the legal authorities that are in place that states can use to change their Medicaid programs during a disaster or public health emergency. And some examples of what has happened in Florida in the past and in other states, just to show you some of the breadth of the flexibilities that states have to adjust their Medicaid programs during a crisis. And then finally, talk about what has changed in the Florida Medicaid program during COVID-19.
Okay, Ann, let me just interrupt you for a second, because there's, I don't know if there's a little background noise coming from you. So you probably might need to talk just a little bit louder, maybe.
Okay.
I don't hear it now. I hear it when you talk, but not too bad.
Okay, sorry about that. So what is Medicaid? You know, that topic in and of itself could take a separate training, but just, you know, at the high level, it's the largest public health insurance program in the country. It's distinct from Medicare. A lot of times people get those two programs confused. Medicaid is jointly administered and funded by the states and the federal government. And so there's 51 different Medicaid programs around the country. And that's because the federal law sets a floor of the different categories of people that must be covered under Medicaid, and also a floor on the benefits to be offered. But then states have a lot of options to make their programs more generous. Since the pandemic, the enrollment in Medicaid has shot up. There's now over 500,000 more people enrolled in the program since February, and the enrollment is now at its highest point ever at 4.3 million. And this demonstrates that Medicaid is doing exactly what it was intended to do, to be a safety net that grows during a time of economic crisis and a public health emergency. At the federal level, the program is administered by the U.S. Department of Health and Human Services. At the state level, it's administered by the Agency for Healthcare Administration, which is the designated state agency in charge of the program. And there are certain responsibilities that have been delegated to the Department of Children and Families, including handling and administering the application and eligibility determination process. A lot of folks are really amazed at the scope of who's covered by Medicaid in Florida. And this is just a visual of the different categories of coverage. Notably, more than half of the Floridians in nursing homes are covered by Medicaid, and nearly half of all the children in this state. Who qualifies for Medicaid? There's a myth that just because you're poor, you're going to qualify for Medicaid, and that's far from the truth. There are very specific categories of people who can qualify for Florida Medicaid, and then for each category, there's varying income eligibility thresholds based on the poverty level. So not to scare you with this visual, but it's really put here to show how complicated this program is, and something you can take home and stare at some more. But it's an example of some of the assistance clients may need in just sorting out whether they can get help through Florida's Medicaid program. So Medicaid plays a really important role during a time of disaster and public health emergencies. And it allows states and localities to meet particular needs of their residents during these times. But Medicaid is a very highly regulated program, which during an emergency can create some barriers for consumers trying to access services and providers trying to deliver them. So Congress has given the federal government and states a couple of pathways for giving the states more flexibilities to change their programs during an emergency. And the most common legal basis for states making some changes is through Section 1135 of the Social Security Act, also sometimes referred to as the Stafford Act. It requires, in order for the protections there to be triggered, there must be an emergency declaration by the President, as well as the Secretary of Health and Human Services. There are, I've noted on the slide, some of the other pathways that states can take to get legal permission to change their Medicaid programs. And if you're interested, if you're a nerd and want to go deeper onto some of that, on my last slide, there's a resource page, and there's a very excellent paper that was done by the Medicaid Payment and Access Commission that really goes more into detail on what states can do under these different legal pathways. To further complicate the landscape, there are also state laws and policies that may need to be triggered to make adjustments to the Medicaid program during disaster. So, for example, under state law, once the governor decides to declare a state of emergency, he has broad authority to suspend the agency rules which would in any way prevent, hinder, or delay necessary action in coping with an emergency. Or he can also direct ACA or the Department of Health to take special measures to address the emergency. Typically, these declarations and policy changes are detailed in executive orders of the governor, or specific state agencies. On the last slide that includes resources, there's a link where you can access the governor's website, where all the executive orders relating to COVID-19 are listed, as well as the executive orders of different agencies. It's important to note that on the healthcare front, often these executive orders from the governor are going to impact more than just the Medicaid program. For example, you've probably heard a lot about changes in nursing home visitation policies. Those apply to all nursing home all nursing homes and all nursing home residents, even if they're not covered by Medicaid. If we're looking at a change specific to Medicaid, it may be a little bit more difficult to get your hands on those written policies because often they're done through maybe agency policy transmittals, or sometimes it's just through some kind of notice on the agency website. And that's typically what's happened with Department of Children and Family application and eligibility changes. The other state law to know about that relates to health care is concerning prescription refills. And during a public health emergency, insurers have to allow for early refills. And if there's no refill authorization, the pharmacist actually has discretion to dispense a 30-day supply when certain conditions are met. Like, for example, if the medication is essential for maintenance of life or the continuation of therapy in a chronic condition. And these are incredibly important provisions. Often, during a crisis, consumers will be particularly anxious if they have chronic conditions about continuing to get their medications. Just a minute to talk about some of in the past, some of the flexibilities we've seen in the Medicaid program in responses to disaster. One example, and this is here to sort of show how broad states have exercised flexibilities under these in crisis situations to have their Medicaid programs be more responsive. For example, in the 9/11 attacks and in instances where there was lead contamination discovered in the city water supply in Flint, Michigan, state Medicaid programs were authorized to expand eligibility so that they could cover more people that were affected by those disasters. In Florida, we have lots of experience with hurricanes, and one example is we were authorized as a host state to provide coverage up to 5 months, Medicaid coverage to Katrina evacuees. Another instance, and this related to the Florida Kid Care program, which is our children's health insurance program, where families are required to pay monthly premiums. The state, during Hurricane Michael, waived those premiums for 3 months while people were contending with that disaster. Now let me shift just to what we're seeing on the COVID-19 front and Medicaid changes, because there's lots of changes and new flexibilities in consumer protections. And they've been triggered not only by the emergency declarations at both the federal and state levels, but also by federal COVID relief laws. And I think maybe one of the most important takeaways of this is that under one of the federal COVID relief acts, the Families First COVID-19 Relief Act, as a condition of the state getting more federal dollars, Florida is prohibited, as well as other states, from terminating Medicaid eligibility for anyone was enrolled in the program on March 18th and any day thereafter. There are very limited exceptions to this, such as when someone dies or moves out of the state. But otherwise, people are supposed to be retaining their coverage, even if they no longer meet eligibility criteria. And this protection is going to remain in place at least through January of 2021 because the federal government just extended the public health emergency through January. Similarly, states, including Florida, are prohibited during the public health emergency from implementing any new Medicaid eligibility restrictions, such as reduction of income levels. And that's, something important to keep at the forefront as there's more pressures on states to deal with budget deficits. I'm not going to go through everything on this slide, but one thing I did want to mention is that there's been truly skyrocketing new use of telemedicine in the Medicaid program, including for behavioral services. And we've really seen an explosion of use of telemedicine since February. And it's very popular with families and providers, and there's a lot of hope that the new policies will continue beyond the public health emergency. More flexibilities here that the state has adopted since COVID-19. I mean, one important one is that Medicaid is now providing coverage for COVID-19 testing and treatment. Other changes were made to make it easier for providers to enroll in the Medicaid program and become Medicaid providers. And in the long-term care arena, there's been a lot of adjustments made, some to ensure that there's enough of a workforce in place to meet greater needs in the long-term care setting, and to retain workers who, because of COVID-19 and public health safety reasons, might not have been able to deliver services such as adult day health care providers. Two things I do want to mention is that there's a couple options that Florida has passed up, that there's still opportunities out there that would help us substantially meet greater needs of particularly the uninsured in this state. First, we could be getting 100% federal funding under the Medicaid program to cover testing for the uninsured. That's been a program that came about from one of the COVID-19 relief acts, and for reasons we don't understand or not aware of, the state has opted not to do this. And of course, we're one of 12 states that haven't expanded our Medicaid program, which means that we're leaving tens of thousands of Floridians uninsured, at a time when people need access to health care coverage more than ever.
And Ann, I'm going to interrupt right now because that follows up with one of the questions that we just had, and you may have just answered it, and that is talk about the impact of the legislatures opting out of expanding Medicaid coverage available from the federal government.
Right. I mean, the conservative projections are that over 800,000 Floridians could qualify if we did expand Medicaid, and we would get substantial federal assistance to do that. There's been a lot of research showing that, we would have billions of new federal dollars flowing through the economy right now, which would help, Floridians, small business, Floridians get back into jobs. So aside from giving people more access to care, so critical during a pandemic, we'd also give a giant boost to our economy if we opted in. So that's something, we need to keep an eye on, that there's a lot of still continued effort to get the legislature to reconsider.
All right, thank you.
Finally, just a word on how people can help, and it's not just legal aid, but I know there's other people in the audience. As you've heard, this can be a very complex topic, how to access health care. And, people are understandably desperate right now to be able to get coverage, to be able to continue their coverage. And we know that there's thousands of Floridians who do qualify for Medicaid right now, but they're not enrolled, and they need help learning about the availability of that coverage and how to apply. They need to know they've got appeal rights if coverage is terminated, and particularly now where even if people don't meet the current eligibility criteria, they have special protections under federal law to keep their coverage. And it's very important as at some point when the public health emergency ends, how will that transition happen back to the new Medicaid normal? We want to make sure there aren't abrupt terminations of eligibility and mistakes that could be, might be made. And so we're going to need a lot of advocacy resources to help people with that phase of the transition. And this is the resource page I talked about earlier. It's links to the state agencies' websites, which are a very important place to check to keep up on what's going on, and some of the national organizations that have put out some excellent resources. And that's it for me. Please feel free to contact me if you have questions after the webinar. Look forward to hearing from you. Thank you.
All right. Thank you, Anne. And thank you, Daniel, Cindy, and Anne for today's presentation. And thanks to everyone who joined us today. You'll get a copy of the presentation and the PowerPoints after we get the video recording. And I want to encourage you to come back next week, Thursday at noon. Our presentation next week will be on FEMA appeals, where our presenter is Tracy Figueroa with Texas Rio Grande Legal Aid. So see you next week. Thanks for joining. Bye-bye, everyone.